Hi, I'm Fiona Henderson. I'm in Germany, just near Stuttgart today, the birthplace of Mercedes. Stuttgart is also one of the places where you can get my favourite German dish, Spätzle. Of course, if you're German, you know what this is, but if you are Australian, you've probably never heard of them. They are a special kind of German noodle which comes with cheese and bacon and onion, and you can get them in the south of Germany, the Alsace in France, Austria, Switzerland. They are really hard to find in Australia, so I love to indulge when I'm in Germany. Today I met with clients and their German lawyer to look at what documents need to be produced as part of their obligations for discovery. Discovery is the process by which parties to proceedings must hand over certain documents in their possession, power or control to their opponents. This is done so that all of the documents that are relevant to the issues in dispute in the proceedings are available to everyone to use forensically as desired. The documents that are to be discovered are set out in a list of documents. This is an itemised list whereby each document is numbered, dated and described. Clients are required to produce all documents in their possession, power or control, including documents that may be unhelpful for their case. The requirement to produce documents in a party's power and control extends beyond just what they have in their archives and may require them to obtain documents from third parties such as their accountant or their lawyer. Documents a party once had but doesn't have anymore must also be included in that list, together with an explanation as to who has them now and when the party last had them. When I first started in practice, general discovery was a huge undertaking. Every document of marginal relevance to the proceedings had to be produced. It was a rite of passage for nearly every first-year solicitor to spend months locked away in a basement, sorting through thousands of archived documents and listing them on the list of documents. It was quite soul-destroying. These days, the discovery process has been significantly curtailed. It usually takes place after the affidavits have been prepared, when the issues in disputes are clearer, and there is a requirement to request categories of documents rather than a general order for discovery of all documents. You are then only required to produce the documents which fall into the categories requested. Mind you, categorising documents and excluding those documents which don't fall into the categories can sometimes be a more difficult task than simply producing everything. Nonetheless, the obligation on a party to produce all of the documents falling within a category is not to be underestimated. Forensic penalties can be imposed on a party who has a document in their possession which should have been produced but wasn't, especially if it is clear that it was deliberately withheld. There are professional obligations on solicitors to ensure that their clients understand their full obligation to produce. This is particularly pertinent with clients and their lawyers coming from a civil law jurisdiction where there is not the same obligation to hand over everything to your opponent unfiltered the way there is here. One of the most difficult tasks of my job is to get clients to understand the extent of their obligations to hand over documents and to convince them to invest the time into digging everything out from their records and to make sure they haven't overlooked anything. Nothing should be held back, at least from your own solicitor. It is far better to err on the side of giving more to your solicitor than to overfilter and later realise that a document is relevant but wasn't produced. If there is a particularly unhelpful document, it is also far better to bury it amongst hundreds of marginally relevant documents in a long list than to draw attention to it by having to produce it on its own later. Once an order for discovery has been made, there is a continuous obligation to produce. This means that if any document comes to a party's attention or into their possession after the list of documents has been completed, it still has to be produced to your opponent. Once a list of documents is complete, the party or one of its officers must swear an oath that the list of documents is complete and that everything has been produced. It is remarkable how often a party is cross-examined on the completeness or lack thereof of their list of documents, and how often a failure to produce a marginally relevant document can be twisted into an inference that the party has something to hide. I'm not sure that this gets anywhere much forensically in most cases, but it does make for a very uncomfortable experience for the witness being cross-examined and can put them off guard when it comes to being questioned on more significant topics. The long and the short of it is this. It is important to undertake the archaeological exercise of locating every relevant document and handing it over to your solicitor to determine whether or not it should be produced. The filtering process should be undertaken at the solicitor end, not the party end. Until next time.